It's the cataracts.
Welcome to the Nacha Incorporated, the #1 news station in the world, giving viewers like you complete coverage of all the important events.
In 1808, the legislature of the state of New York granted to Robert R. Livingston and Robert Fulton exclusive navigation privileges of all the waters within the jurisdiction of that state, with boats moved by fire or steam for a term of 20 years.
Aware of the potential of the new steamboat navigation, competitors challenged Livingston and Fulton by arguing that the commerce power of the federal government was exclusive and superseded state laws. Former New Jersey Governor Aaron Ogden had tried to defy the monopoly, but ultimately purchased a license from the Livingston and Fulton assignees in 1815 and entered business with Thomas Gibbons from Georgia.
The partnership collapsed 3 years later when Gibbons operated another steamboat on Ogden's route between Elizabethtown, New Jersey, and New York City that had been licensed by the United States Congress under a 1793 law regulating the coasting trade. The former partners ended up in the New York Court of Errors, which granted a permanent injunction against Gibbons in 1820.
Aaron Ogden filed a complaint in the Court of Chancery of New York asking the court to restrain the thug Thomas Gibbons on these waters, and so this court case begins.
All rise for Honorable Chief Justice John Marshall.
You can take your seat. This is the case Gibbons v. Ogden on the matter of Thomas Gibbons' right to operate the water within the jurisdiction of the state. Present in the courtroom are the defendant, Thomas Gibbons, his attorneys, Thomas Addis Emmett, Thomas J. Oakley, and prosecution, Aaron Ogden, his lawyers, William Wirt and Daniel Webster. Is the prosecution ready to present their opening statement?
Yes, Your Honor. Ladies and gentlemen of the jury, Aaron Ogden has charged Thomas Gibbons with unlawful use of his licenses to navigate the waters given to Ogden by the state of New York. We base our case on the fact that states often pass laws on issues regarding interstate matters, and that states should have fully concurrent power with Congress on matters concerning interstate commerce. The defense will argue that Thomas Gibbons had a...
Hey, yo, hold up. You can't be all rude and stuff telling the court what the defense will argue in order to state that we must have a separate trial regarding your clairvoyance.
Yeah, what he said.
Mr. Wirt, if you would, shut up. I'll remind you that this is a Supreme Court case, not a TV show.
Oh,
Mr. Oakley, continue.
As I was saying, the defense will argue that Thomas Gibbons' steamships were licensed under the federal government. However, the prosecution believes that the federal government should not have the power to supersede an exclusive privilege granted by the state of New York. Therefore, we gather here to establish the extent of powers the federal government has over commerce within and between the states.
Thank you, Mr. Oakley. Mr. Wirt will now hear your opening remarks.
All right. Your Honor, if I may, this is not a statement. I'm the real talking here, okay? My client, Thomas Gibbons, was unjustly charged for unlawful use of his license to navigate the waters. That no-good imbecile had his steamship's license under the federal government, as he talked about in his other talk, that one he said earlier, okay? In fact, steamships were licensed under the Act of Congress entitled An Act for Enrolling and Licensing Ships and Vessels to be employed in the coast and trade and fisheries and for regulating the same. Now, when my swagger client was charged with this absurd allegation, enrolling and licensing ships were exactly what he was doing.
Objection, Your Honor. Assuming facts, not in the evidence.
Hey, who you think you are making all these objections and crap? You can't object to my statement. May I remind you that my name is Mr. William Wirt, and I do not get everybody got to respect that name in that case.
Mr. Emmett, you're not allowed to object to Mr. Wirt during his opening statement. And Mr. Wirt, calm down, continue your statement, and let me remind you that there's no smoking in the courtroom.
As I was saying, shut up. As I was saying, my client ain't got nothing to do with this breaking down American law in any way, shape, or form. As for the prosecution's belief that the federal government should not have the power to supersede the state, I would like to tell y'all fools in the court that our swagalicious Constitution, according to Article 1, Section 8 of the Constitution, Congress has exclusive national power over interstate commerce.
Objection, Your Honor. Bullshit.
I don't know where y'all were raised, but where I was raised, we do not use these sort of words in general, or in the presence of ladies, or in a courtroom. And even if that were a valid objection, you cannot object during his opening statement, as I have already reminded you. Please continue.
Yeah, I would like to once again remind you, the court, that my name is...
If you mention your name one more time, I'm kicking you out of this court. Continue and finish up your statement.
Oh, hell, you know what? I refuse to go on. Mr. Webster will take over from here.
Our main point here is that we believe that the federal government does not have the right to regulate commerce between within the state and between states. We believe that the true issues of this case are the extent of the powers the state have on regulating commerce, a power that the federal government has rightfully under Article 1, Section 8.
Thank you, Mr. Webster. Wow, things are already getting heated in there.
Yeah, nothing like watching some of the best in the law going at it.
Reminds me of the good old days.
Well, tell me, what do you think of the case so far?
Well, this is no doubt one of those cases that allows for great arguments on both sides. It's going to be very interesting to see the decision of Chief Justice John Marshall he will make in these respective statements.
Why don't you walk our viewers through the issues that he's going to be factoring in order to make his decision?
Well, the statements from both sides raise several key issues regarding the powers of the federal and state governments. I think there are ultimately two main questions that need to be answered in this case. The first is, can a state make a law that regulates a purely internal affair regarding trade or the police of power, or is it subject to the federal government? And second, does a state have the power to grant an exclusive right to the use of the state waterway, inconsistent with federal law? And lastly, as my final parting note, I believe that the key to resolving these issues is understanding what the word commerce means in context of the Constitution. What exactly could the federal government regulate under this provision? Was the carrying of passengers a form of commerce, and should the word commerce be read narrowly as in boxes and barrels, or broadly to include all business relations for the purpose of trade? Were the steamboat licenses of the state of New York in conflict with the national government's authority to regulate commerce? And if so, was the requirements for all steamships in New York waters to be licensed by the state constitutional? I mean, these are all questions that Chief Justice Marshall has to address in his final decision, and I guess we'll find out soon.
It's a really interesting point, so we'll stay tuned and we'll let you know what Judge John Marshall comes up with.
Whoever say I just walked away,
You're going down.
Oh, hell no, we won, fool. Oh, hold me back. Hold me back. Shit, I'm getting out of here.
I came in like a wrecking ball. I never hit so hard.
All I do is win, win, win.
I walk a lonely road, the only
Jane, gold all in my chain.
No, I'm gonna do it.
Okay. If I may, this is not a statement of being a damn.
Okay, hold on, sorry.